This lecture is about causation, actual and proximate cause, and damages and defenses in negligence cases and in strict liability cases. Actual, proximate causation, and damages and defenses. Now we're carrying three problems along as examples, and let me remind you very quickly of what those problems are. One is the Transco problem, the other is the electric problem, and the third is the plumber problem. In the Transco problem, Transco had an obese train driver driving the train that derailed, and Paul owned land nearby and sued. In the electric problem, Electric put a power pole down near a highway when they knew it was being hit every 3 weeks, and along came driver, then hit it, and Peter, the passenger, died. And they're suing the electric company, among other things, claiming the electric company was negligent when they put that pole down there. And finally, the plumber case, where the plumber connected two incompatible pipes together, did not use a plastic connector, and after due time, the pipes corroded. Hot water under pressure came out of the pipes, damaged the swimming suits in the store where the pipes were, scalded a customer named Carrie. The swimming suit store was owned by a woman named Amy, so her swimming suits were damaged. Carrie, the customer in the store, was scalded. And Emma was an employee who was discharged because the store had to close for repairs. And they're all suing the plumber. Now, to run through where we are in those problems, we want to use those three examples for causation. Let's look quickly at the duty and breach for each of them. For a Transco, obviously, Transco owed a duty of due care to the owners of land near the tracks, and we claim they, I'm just summarizing now, you have to do this by rule application. But you'll end up with Transco owing a duty of due care to those with land near the tracks. That duty was breached. We claim it was breached by the balancing test. In the case of Electric, they had a duty, Electric owed a duty of due care to people who drove their cars on that road because they were foreseeable plaintiffs. Electric's duty was breached under the balancing test also. Plumber owed a duty to people who were going to be using the store where the pipes were repaired. They were foreseeable plaintiffs. Plumber breached his or her duty using the violation of standards of the profession or skill. So we have duty and breach in all three cases, and therefore this brings us to our next section over here, causation. Causation has two parts, actual and proximate cause. Let me tell you about each of these. First of all, they're measuring two different things, and it's important that we distinguish. Actual cause is asking the question, can you say, but for this breach of duty, whatever the breach of duty was, could be negligence, whatever the breach was, whatever the wrongful conduct of the defendant was, whatever that wrongful conduct was, we're now asking the question, can you say, but for that wrongful conduct, this harm would not have happened to the plaintiff? Okay, that's our actual causation part. Problem is that if you leave it at that, you can end up with a butterfly effect. Because even if you can prove with absolute certainty that this wrongful conduct caused the butterfly effect where way down the line some bad thing happened, well, how far out this ripple are you going to hold people liable for the outcomes? How far out the ripple? And that's what proximate causation is about. How far out the ripple of events is the person liable. The events which are beyond the person's liability, we say those events were not proximately caused by the defendant's breach of duty. Even though they might have been actually caused, we're saying from a legal point of view, we won't recognize that causation. So we say they're not legally caused or not proximately caused. So events which are not that far out on the chain are proximately caused. The ones which are beyond that are not proximately caused. And in order for a defendant to be liable, their conduct, their breach of duty, has to be the actual cause and a legally recognized cause, actual and proximate cause. Now, there are two ways in which the proximate causation problem comes to us. One is through direct causation and the other is indirect causation. In the direct causation cases, we have the situation where A caused B, caused C, caused D, and so forth. And the question is, how far out that ripple effect are you going to hold the defendant liable? And the answer in these direct causation cases is really a play on words. One set of jurisdictions says, in direct causation cases, the defendant is liable for all the harm directly caused except for extremely remote harm. Other jurisdictions say in these direct causation cases, the defendant is only liable for the foreseeable harm that's directly caused. And Prosser says it really doesn't make any difference that what one jurisdiction says that beyond this point the harm isn't foreseeable anymore, the other jurisdictions are saying, well, beyond this point the harm is extremely remote. It says if you look at the cases around the United States, they all end the liability about the same place in these direct chain cases. And the way you know about where that is from the case law. That's what the bar examiners want to know. If you have some sense of how far out this chain there are people liable. The second aspect of proximate causation is the case of indirect causation. In indirect causation cases, this means that the wrongful conduct occurred and the ripple of, but someplace along the ripple effect came some outside event that affected the outcome. And if you've got an outside event that comes in and affects the outcome, is that going to terminate the original defendant's liability or not? And so if it will terminate the original defendant's liability, of course we say that outside event was a superseding event. And so in our second case of analysis of proximate causation is the case of indirect causation. And this is a case where the defendant's wrongful conduct, there was causing some effect, but along came some outside force that combined with it and affected the outcome. And so now the question is the original defendant still liable or not? And how do you analyze that class of problems? And that's what we're about to do right now. Here, you see that the actual causation problem asks, can you say, but for, and this but for is but for the defendant's wrongful conduct. You don't have to repeat the wrongful conduct here. You've already established that the defendant was negligent at this point, or the defendant did something wrong, strictly liable. But what if it's but for the defendant's wrongful conduct that you have already proven at this point? You've proven breach of duty already, so you don't have to reprove it here. But for the defendant's wrongful conduct, this harm wouldn't have happened, or, of course, substantial factor can be used. In that case, you have satisfied the actual cause requirement. This brings us to the proximate cause, and there, in the direct causation cases, again, what you have is some jurisdictions say the person is liable for all the harm directly caused subject to extreme remoteness, and other jurisdictions saying the defendant is only liable for the foreseeable harm caused by the wrongful conduct. And Prosser says that's just words. They really end in about the same place in all these direct causation cases. Then comes the indirect causation cases, and there the question is, what do you do when after the defendant was negligent, some intervening event occurred? Now, please be clear that before the defendant was negligent, everything that had already happened, that's the stage upon which the defendant acted. So the things which happened before the defendant was negligent, those are not intervening events. Intervening events must be events which occurred after the defendant was negligent. Now, otherwise, what happened before the defendant was negligent is a part of the stage upon which the person acted. So how do you analyze a situation where you have an intervening event which affected the outcome? And the answer is, this is a crisscross diagram that does a good job of that. Now, please don't draw a crisscross diagram for the bar examiners and say, read my diagram, okay? You gotta act like and write as though you're analyzing in your erudite thoughts about foreseeability and public policy and such things. But this is what you end up with. Don't be foolish enough to put this on your paper. If you have, in indirect causation cases, which we're analyzing now, in indirect causation cases, you first identify the intervening event. And the intervening event is either foreseeable or not foreseeable. And you classify the intervening event, whatever it was, as foreseeable or not foreseeable. Now, in order for an event to be an intervening event, it must be an act of an animal, act of a person, or an act of nature, like an unprecedented storm or an earthquake or something. Intervening behavior of molecules and intervening behavior of bacteria, etc. That's not what we're talking about. They need to be intervening events of an animal or person or acts of nature in order to qualify as an intervening event, and it must occur after the defendant was negligent. So you identify your intervening event and you classify it as either it was expected to happen or it was an event you did not expect to happen. Foreseeable or not foreseeable. Then you look to the outcome. If the result or the outcome was not particularly changed by this intervening event, then the results were still foreseeable. So the results that actually occurred was either foreseeable or not foreseeable. So these are the four things in your table. Intervening event was foreseeable or not foreseeable. The result was either foreseeable or not foreseeable. Okay, and with those four things, you have lines that go straight across and lines that crisscross. The ones that go straight across are very simple. If you have an intervening foreseeable event and the result was foreseeable, it didn't change the outcome very much, do not terminate liability. That's not a superseding event. And that makes a lot of sense. You expected the event to happen, it's foreseeable, and it didn't change the outcome anyway because the outcome was foreseeable. No one's going to terminate liability on that basis. The second one going straight across, where the intervening event was not foreseeable, things like intentional torts, normally not foreseeable. Reckless conduct of others is normally not foreseeable, whereas the negligence of others is generally foreseeable. So if the intervening event was not foreseeable and the outcome that it caused changed quite a bit, was not the foreseeable outcome, everybody agrees to terminate liability when that happens. And the intervening event was not expected. It produced an unexpected outcome. Terminate liability. Everybody agrees. The crisscross ones. Let's take the case where you have an intervening event which was not foreseeable because you didn't expect it to happen, but it happened anyway. So you have an unforeseeable intervening event. But it didn't change the expected outcome anyway. And so if it didn't change the expected outcome because that was foreseeable, then do not terminate liability, because the outcome wasn't affected that much anyway, even though you did not expect this intervening event. Finally, the crisscross going down, if you have a foreseeable intervening event and it produces an outcome which is not foreseeable, then there's a split of authority as to whether or not to terminate liability. So let's do this analysis with some problems that we have. Let's begin with the case of the electric company. The electric company put the pole in the same location where it had been hit every 2 weeks, and indeed it got hit again. And we say electric company acted negligently. We say electric company owed a duty of due care to people in those cars coming down the road. And we claim that putting that pole back in that same location was a breach of duty. And we prove that by using the balancing test. And now we come to causation. Was that negligence by electric in putting the pole back there, was that the actual and proximate cause of the death of Peter? Well, actual cause, can you say that but for them putting the pole back in that same location, Peter would not have been killed? Well, I don't know. If they'd moved the pole off the road a ways, maybe the driver would have gone off the road anyway. But you can certainly use substantial factor in saying the pole being placed there was a substantial factor, that negligence. Next, proximate cause. Keep in mind that electric put the power pole in this location, we think negligently, and their breach of duty was the duty owed to people coming down the road in cars. Peter is one of those people, and Peter's driver acted negligently, but when the car crashed into the pole, that created electric's liability to Peter. So we need to look for events which happen after that to see if electric's liability was terminated. So the liability is created when the driver hit the power pole. So what happened after that? Well, along came rescuer. I don't think rescuer acted negligently in trying to help get Peter out of the car, even if the rescuer was negligent. That the negligence of others is always foreseeable. So even if the rescuer was negligent, you would have a foreseeable intervening event. That is, the rescuer acting negligently. Did it affect the outcome? Well, not really, because the expected outcome when you hit power poles on the highway is great bodily harm or death. And that's what happened to Peter, whether rescuer was there or not. So the rescuer did not change the expected outcome. So we have the rescuer is a foreseeable intervening event of a person, did not change the outcome, it was foreseeable, so the rescuer would not terminate electric's liability. After rescuer came to try to help, along came reckless, and reckless hit them because the car was still partly on the road. Now let's suppose that reckless was driving recklessly for our purposes. If reckless was driving recklessly, what reckless did happened after electric was negligent, and so we have an intervening event. But what reckless did, to drive recklessly, is not foreseeable. So reckless was an unforeseeable intervening event, and was the outcome after reckless hit them foreseeable or not foreseeable? Well, the outcome that you expected from hitting power poles on the highway is great bodily harm or death. And reckless did not change that. So the outcome was the foreseeable outcome that without reckless. So with reckless, what you have is an unforeseeable intervening event, driving recklessly, but it produced a foreseeable outcome, and so we do not terminate liability because it didn't change the outcome. So if electric was liable, the subsequent behavior of the rescuer and the subsequent behavior of the reckless driver did not terminate electric's liability. Let's next look at the plumber. Now, the plumber, you recall, connected these incompatible pipes, and Emma, the employee who worked at the swimsuit store, was laid off because the store had to close. And Emma sued the plumber. Now, first we understand that the plumber does not owe Emma a duty not to cause her this pure economic harm, loss of her job. So most jurisdictions, Emma will get no place in suing plumber because plumber doesn't even owe her a duty. However, there are a few jurisdictions who cut off Emma's right to recover under proximate causation instead of under duty. And they say that Emma, that after plumber has done whatever plumber did wrong, breached his duty of care, you look out the line of consequences, and one is that Amy's swimming suit store is damaged, the customer is scalded, okay, and now once removed from the direct injury is Emma's loss of employment. And the courts are simply saying, no, that's too far out the chain. And so the harm which was caused to Emma, the employee who lost her work, was not proximately caused by plumber. And so plumber is free from liability when Emma sues, either because plumber did not owe Emma a duty at all, or in other jurisdictions, a plumber was not the proximate cause of Emma's harm because she's too far out the chain of causation. That takes care of electric. We know how we would use this diagram for electric. Plumber, we just talked about what to do in the case of plumber. And in the case of plumber, we don't have an intervening, well, I don't know, in the case of, anyway, we talked about plumber, we've talked about electric, and the final one we want to talk about is Transco. Now in Transco, the company put this, the engineer on who was not a safe driver because the engineer had a heart attack and so forth. And we think that that was a breach of duty of care owed to the people who own land near the tracks. And Paul was one of those people. And Paul sued Transco for breach of duty of care, and we think that Paul ought to win. Problem was that in this case, Paul left his land where he operated a greenhouse and wouldn't come back for 6 months because he didn't think it was safe. But he apparently was the only one. The actual damage was not that significant. Most people came back and continued to conduct their business shortly thereafter. There was no lasting damage at all. I don't know what happened. Maybe the toxic materials never spilled, but it doesn't say what happened. It does tell us that there was no lasting effect. But Paul thought there was. And Paul was hypersensitive. And Paul wouldn't come back on the premises for 6 months. And Paul kept his greenhouse closed for 6 months. And the question is, are you going to let Paul recover for that? And the answer is that either the Transco does not owe Paul the duty not to trigger his hypersensitiveness. Either we don't owe him that duty, or if we do, the consequences of what we did is too remote, because the consequences are his mental reaction due to his mental condition, his bizarre and unexpected and unforeseeable mental reaction, that is so unforeseeable that we, Transco, are not liable for things which are beyond the foreseeable harm. So that's how you would handle that. Both of these, as you can see, are foreseeability problems. So what we see regarding foreseeability then, in summary, or what we see regarding causation, is that the harm complained of, that the defendant's breach of duty must be the actual cause. That's usually pretty easy. And the harm must not be too remote. In the case of direct causation, the rule is that the defendant is liable. They say it in two different ways. One is that the defendant is liable for all harm directly caused except for extremely remote harm. And other jurisdictions say the defendant is liable for only the foreseeable harm in direct causation cases. And Prosser says the difference between those two is just language. That if you look at the actual cases, they end up ending liability in about the same place in these direct causation cases. In the indirect causation cases, we look at was the intervening event superseding or not? And we look at this pattern. The intervening event will either be foreseeable or not foreseeable. The outcome will either be foreseeable or not foreseeable, and you use the pattern that is shown here. Next comes damages. The damages which you hope to collect must meet these four criteria. The damages must be actual, causal, foreseeable, and unavoidable in the sense of there being a duty to mitigate whatever harm you can within reason. Actual, causal, foreseeable. Some people here say unavoidable. It's all the same stuff. Unavoidable. Actual means that the damages that you want to collect must be actual in amount. And actual in amount means that the amount is not too speculative. Please notice that there's an exception to this, and that is in situations where you know that the harm occurred, but it's difficult to reduce it to a dollar amount. Then rather than let the tortfeasor go free by saying we can't set the amount, the courts allow the plaintiff to be much more speculative. Somebody is blinded by the tort of the defendant. Well, how much is that worth in dollars? Well, you know the person is blind. You've got all kinds of medical evidence of that. But how much is that worth in dollars? And you can see when you try to reduce it to an actual amount, it's going to be speculative. And so the exception here is that in those cases where you know the harm occurred, but you cannot reduce it easily to specific amounts, you allow the plaintiff to be a lot more speculative as to what blindness is worth, what loss of mobility is worth, what loss of consortium is worth, so forth. Actual in amount, causal, same stuff, but for or substantial factor. When you get here, you've already done this part, so you don't have to do it again. The causal would be but for or substantial factor. Foreseeable, foreseeable simply means that it means two different things here. In tort law, this foreseeable just means proximate caused, okay? Approximately caused. let me tell you more about this foreseeable. There's a difference in what is meant by the concept of foreseeable in contract law versus what it means in tort law. And this is real fundamental, and you need to be sure to understand this. So let me explain it now. In the case of contract law, you all know the Hadley versus Baxendale case, which says the only damages that you can collect for breach of contract are those which were foreseeable at the time the contract was formed, foreseeable by the person who may have to pay these damages. In the case of Hadley Baxendale, the rule is that you can only collect the damages which were foreseeable when the contract was formed. Now, if the damages later turn out to be a lot more or a lot less than what was foreseeable when the contract was formed, all you get are the damages which were foreseeable when the contract was formed. And that's the way it is in contract law. In tort law, we use the same rule. We say the damages that you can collect in tort law are only the foreseeable damages. We say the same thing in both contract law and in tort law. But in tort law, when we say the damages are only the foreseeable damages, we really mean hindsight, not foresight. In the case of contract law, we're talking real foresight when the contract was formed. In the case of tort law, what really happens is the two people have their accident or whatever the liability event is, and you look backwards from the harm that you're trying to collect for. You say, here I've been injured in this way, and you look backwards to whatever the defendant did wrong. And if what the defendant did wrong is too remote, so that as a matter of public policy, the wrongful conduct and the final injury are too remote from each other, then you won't be able to collect. The harm wasn't foreseeable. But if the harm is not too remote from the wrongful conduct, then we say it was proximately caused, it is foreseeable. And it's up to the public policy to sort of establish where these boundaries are, and that's what your case law is about. But the key point here is that in tort law, you're always looking in hindsight, after the injury happened, is it connected to the wrongful conduct enough? If it is, we say this harm was proximately caused, or we say this harm was foreseeable. But if the harm is too remote from the wrongful conduct, we say this harm was not proximately caused, or this harm was not foreseeable. And so, again, Prosser says the term should have been this harm is not hindseeable, but he says you're never going to get people to change that. So contract law, true foreseeability. Tort law, it's actually hindseeable, but we still call it proximate causation. Now, finally, I want to point out that in tort law, we're talking about foreseeability or proximate causation. In tort law, that the harm that you can collect falls into these two categories, general damages and special damages. Also, in contract law, we use general damages and special damages. But these have different meanings in contract versus tort law. And I want to clarify that now. Starting with tort law, what we mean by general damage, well, let's not start there, I'm sorry. Start with contract law. In contract law, we have general damages and special damages. Both of these must be foreseeable. You don't collect any damages in contract law which were not foreseeable when the contract was formed. But the problem is that some damages in contracts are automatically foreseeable because people are treated as understanding that harm is always foreseeable. For example, if I contract to buy widgets from you and you don't supply the widgets and I buy them someplace else, it's understood that if I have to pay more, you owe me the difference in damages. And so those are automatically foreseeable because everybody's presumed to understand that. And that's called the standard measure of damages. So if I'm supposed to build a house for you, and I breach the contract and don't, and you get somebody else to build a house and it costs more money, I owe you the difference. And everybody understands that. And those are called the general measure of damages, because a standard measure of damages, everybody understands it. You don't have to say anything about it in the contract, it's just understood. And so in contract law, here in contract law, the general damages is this standard measure. The cost to cover for contract work that wasn't done, the cost to cover for goods that were not delivered, and so forth. Special damages in contract law are damages which are beyond these standard measure of damages, but which actually were caused by what the breach of contract did. For example, let me suppose that I make widgets at my factory, and I'm buying 100,000 widget mobiles from you to go into my widgets. And most of my sales are at Christmas time. And when you make the contract with me, let's take two hypotheticals. One is where I make it clear to you that if you don't deliver the widgets on time, that I won't be able to find replacements, and I won't be able to make my Christmas sales, and it's going to cost me $1 million in profit, or some large amount of money. If you understand that when we contract, so you can set your price accordingly, and you fail to deliver on time, I can collect those damages, because those damages were foreseeable when the contract was formed. Now, my loss of profits on the sale of my widgets is not a part of the standard measure of damages. The standard measure of damages is if you don't deliver the widgets, I go out and buy the widgets someplace else, and if I have to pay more money, you owe me the difference. That's the standard measure of damages for your not delivering the widgets. But I want you to pay for my lost profits. That's outside the standard measure, and that has to be made foreseeable at the time we form the contract. I have to do something to make sure you are aware of that. I mean, it's not that I have to do something, it's that you really have to be aware of it, either because I told you or it was obvious or for some reason. So over here then, in contract law, the general damages are the standard measure, and the special damages are the damages that you have to make them foreseeable or you can't collect them. And those are called, they have three names. They're called special damages, they're called consequential damages, they're called Hadley versus Baxendale damages, and it's all the same stuff. Over here in tort law, we also break them up into general and special damages. In tort law, we say the general damages is the kind of harm you ordinarily expect from that tort. That doesn't help you very much, but that's the general rule. The kind of harm and the special damages are something else. And let me tell you what's really going on here so we can get past the gobbledygook. What's happened here is that when a person commits a tort, and certain kinds of damages like loss of mobility, loss of consortium, loss of eyesight, that sort of thing, those kinds of damages you can't really prove with a piece of paper. Whereas my loss of income because I was away from work, or my medical expenses or my car repairs, those I can prove with a piece of paper. Now, please don't say something to the bar examiners as dumb as proving it with a piece of paper. I'm just trying to convey the understanding to you. If you say that to the bar examiners, they'll give you a bad grade. So what I'm saying to you, though, is that there's some damages that you can prove with a piece of paper. And the ones that you can prove with a piece of paper, those are the special damages. Special, not general. Those are the special damages if you can prove it with a piece of paper. Medical bills, loss of wages, car repair, that sort of stuff. The damages that you cannot prove with a piece of paper are going to be such damages as loss of reputation, loss of consortium, a loss of mobility, loss of eyesight, those sort of things. You can't prove those with pain and suffering. You can't prove those with a document. And so the general damages turn out to be that kind of stuff. Now, if you are dumb enough to say to the bar examiners, general damages are the ones you can't prove with a piece of paper and the special damages are the one you can, they will fail you, and they should. I'm just giving you that to make it clear to you that that's what goes on. You need to say it in some much more sophisticated way. And the way you say it is that the general damages are the kind of harm you normally expect from that type of tort. So that if it's an impact tort, you expect pain and suffering. If it's a burn, you expect disfigurement. So you say it's something like that. And then the special damages are the ones that are outside of these general damages. Damages which are not the general ones, and they turn out to be these ones I told you about, but don't dare say it that way. Okay. That takes care of our torts and contracts, how proximate causation is handled, foreseeability is handled, and finally the duty to mitigate. Of course, it simply says that whatever harm you could have reasonably avoided after someone has committed a tort and you're injured, whatever harm you could have reasonably avoided by reasonable efforts on your part, you can't collect beyond those. You can't collect for those. Finally comes the defenses. Now, there are two classes of defenses for the torts. They are the defenses where you try to prevent the other side from making out their prima facie case, and the other type of defense are the affirmative defenses. So if the plaintiff has to prove duty, breach, causation, damages, the defendant may try to defeat any one of those elements, and the defendant would win. Okay? And that's one way the defendant might win, is to prevent the plaintiff from proving an element with a preponderance of the evidence. The other way that the defendant might win is through the use of affirmative defenses, saying that, well, even if all those elements are satisfied, plaintiff still loses. And the affirmative defenses are shown here on the board: release, statute of limitations, contributory negligence, comparative negligence is a partial defense. Let's talk about each of these. The release. If you sue several defendants and you want to settle with one of them but not the others, then if you gave that person you settled with a release, the common law took the position that a release of one is a release of all. They reached that conclusion by saying you only had one cause of action against this collection of people who injured you if you joined them in the same suit. Now, we all understand if people form a joint enterprise and injure you, then there's joint and several liability. But at common law, if they all injured you and you sued them together, so you joined them, even though they didn't conspire against you, you joined them for the injury that you received, then the theory is you have one cause of action against all of them collectively. And if you release anybody, that's a release of all. And so what happened is three things have happened to that rule. And it's important for you to know these three things that have happened to that rule. Number one, in the great majority of jurisdictions, the rule has been abolished. And where the rule has not been abolished, you can avoid being victimized by the rule by giving the person that you are settling with a covenant not to sue. You have to give them a covenant not to sue, not a release, in the few jurisdictions that still follow the rule. In other jurisdictions where the rule has been abolished, it's either been abolished by statute in a lot of jurisdictions, and it's abolished by case law in a lot of other jurisdictions. But in almost all jurisdictions, it's dead. But where it's not, you need to use a covenant not to sue. And the bar examiners have actually tested that point. That's the release. Statute of limitations is, the bar examiners don't generally test this, but if something's very old, you'd be expected to know the statute may have run. Contributory negligence, as you know, used to be contributory negligence is a total defense. If you can show that the other side was negligent at all, then that's a total defense, if the plaintiff was negligent at all. That obviously is an unfair and harsh result, and almost everyone has converted to comparative negligence, where the parties compensated according to the relative negligence of each of them. So that's how this whole system works. If you have a problem, a bar exam question dealing with negligence, that the strategy should be to go right down the list so that you have an element-driven answer. You don't go down the facts, you go down the elements. Duty, all the things we talked about. Breach, use several, all of these mechanisms that you can. If there's more than one, use them. Duty, breach. Then over here is the causation. Actual cause, but for a substantial factor. Then go to proximate cause. Use headings each time. Go to proximate cause, and after you have completed the proximate cause, go to damages. Most of the time in a typical torts problem, you will not have very much that you can say about damages, but say what you can. If you're going to have a lot to say about damages, it really ends up being a remedies problem. But still, do what you can, get all the points you can out of it. And finally, the affirmative defenses. What we don't have here is contribution. Release, statute of limitations, contributory negligence, comparative negligence, and contribution should be here. Let me mention contribution right now, and then we'll close. Contribution and indemnity. So the last two we're going to talk about are right here, contribution and indemnity. I'm going to erase this to make sure you understand. Contribution and indemnity. Contribution is a suit which is brought between defendants. So the plaintiff sues multiple defendants and collects, gets judgments against them all, and then collects all the money from one defendant. Well, that defendant wants the other defendant to contribute their fair share, and they would bring a suit in contribution. The common law rule was that these defendants could not bring a contribution suit because they were all bad people, and the courts didn't want to hear these bad people squabbling among themselves. That's a ridiculous rule, and Prosser and others have said so. But the way the rule works now is that if these multiple defendants were intentional tortfeasors, then the court will not hear a contribution suit between them. But if they're merely negligent tortfeasors, then the courts will hear contribution suits between them. Finally, the next question is, if you bring a contribution suit, do the people, let's say there are 5 defendants, do the defendants each pay 1/5, or do the defendants pay equitably according to their degree of fault? And there's a split of authority. The majority rule is that they pay equitably. Now, contribution is different from indemnity, because in the case of contribution, what you have is several tortfeasors, all of whom did it. Defendant 1 and defendant 2 and defendant 3, they all did it. But the plaintiff collected too much money from one of them, and that person says to the others, pay up. Okay. That's the contribution suit. The indemnity suit is different. The indemnity suit occurs where one person is actually paying for what somebody else did. And you see that in these cases like respondeat superior, where the plaintiff sues the employer for what the truck driver employee did. And the employer then has to pay for the conduct of somebody else, pay for the conduct of the employee. And that's when indemnity comes into the situation. There are three circumstances where indemnity, to which indemnity applies. Three of them. Number one is the case where there is a rule of law that causes one person to have to pay for what the other one did. Okay? So if I'm the employer, I pay for what my employee did, but I'm entitled to get full indemnity back from the employee. If I own a car and I let someone drive my car and they injure someone, I am, as a permitted the person to use my car, I am liable for the harm they caused. So even though I may have to pay for what they did, I am entitled to full indemnity to get my money back from them. If I am a driver of a car and I injure a pedestrian, and the pedestrian goes to the hospital and gets negligent medical care at the hospital and finally recovers, and there are two harms that we're looking at. I originally broke the patient's leg, and I'm liable for that because I drove and hit it negligently, the way the facts say I was negligent. So I'm liable for the broken leg. But when the doctor treated this person, there was some malpractice that aggravated the circumstances. The leg got all infected and stuff. And so I, the person who broke the leg, am still liable for what the doctor did, because what the doctor did was just intervening negligence, and the negligence of others is always foreseeable. So the intervening negligence of the doctor did not terminate my driver's liability. And so I end up having to pay not only for the broken leg, but I pay for what the doctor did too, because the doctor's negligence, it was not a superseding act. So I have to continue to pay. So under that circumstances, I will have to pay not only for the broken leg, but also for what the doctor did, but I'm entitled to full indemnity from the doctor because I'm really paying for what that person did. So whenever the rule of law makes one person pay for what the other one did, you're entitled to get indemnity back from the actual wrongdoer. Now these people are sometimes called active and passive tortfeasors, so that in the case of the employer and the truck driver employee, the employer is the passive tortfeasor, the employee truck driver is the active tortfeasor. Now, I said that there were three circumstances where indemnity applies, and one of them is the active-passive tortfeasor case I just told you about. The other one is by contract, where basically insurance contracts usually, where if I'm injured and the insurance company promises, and I have to pay, the insurance company promises by contract to indemnify me for my losses. So indemnification by contract with insurance companies is the second way. And then the third way that indemnity occurs sometimes is in a small minority of jurisdictions, and it's only in a few jurisdictions where this rule exists. And this rule says that if there are two tortfeasors and one of them is dramatically more culpable than the other, that the one who is dramatically more culpable may be required to pay the whole thing. You might see this in a situation where there's a car accident at the corner and two people hit this third car. Well, one of them was aiming at the third car, trying to hit him because they were trying to kill the passenger. And the other person who got involved in it just drove negligently and hit the third car. Okay, well, here's a case where one person is grossly more culpable than the other, and a few jurisdictions will say that the relatively innocent person is entitled to full indemnification from the one who is grossly more negligent. It's only in a few jurisdictions, grossly more culpable. That's only true in a few jurisdictions. So that takes care of contribution. Contribution, by the way, when you have injuries caused by multiple defendants, and if you can separate out the injuries, defendant number 1 broke my leg, and defendant number 2 broke my arm, and defendant number 3 did something else. And if you can separate out the injuries, defendant number 1 hit the right fender of my car, defendant number 2 hit the left fender of my car, and so forth. If you can separate out what the defendants did, okay, then you sue each person for what they did. And you can't, there's no contribution suit. But if several people injured your right front fender, okay, now you sue them all, and they can sue each other for contribution. But you need a situation where the harm is not separatable. Because if the harm is separatable, you sue each person for the harm they did. If the harm is not separatable, then you sue them collectively, and they sue each other for contribution. And that takes care of these affirmative defenses. Okay, that completes our analysis of the negligence and strict liability cases. Once again, duty, breach, actual cause, proximate cause, damages, and the affirmative defenses. That completes this lecture.